Hello everyone and welcome back to Forensics. In our last video, we talked about fundamentals of crime scene processing. Today, we will discuss what evidence is, different categories of evidence, and admissibility of an evidence in court. So, to begin with, what is evidence? Evidence is anything that can help to establish the authenticity of a fact. It can be in the form of an object or document or alibi, etc. These are presented in court to prove the innocence or guilt of a person held accused of a crime. What are the different categories of evidence? There are majorly four types of evidence: real or physical evidence, demonstrative evidence, documentary evidence, and testimonial evidence. Real or physical evidence is the one which is generated as an effect of crime itself. For example, the fingerprints of a suspect on the knife stained with the blood of victim. In this case, the knife, blood, as well as the fingerprints are all real evidence. Number 2 is demonstrative evidence. This is the type of evidence which is created at later stages by the investigator to explain the significance of the real evidence. For example, charts or diagrams of hair or fiber, etc., or reconstruction of crime scene using available facts in addition to the observation of the investigator. Documentary evidence. The production of documents to prove or disprove a fact. For example, if the accused claims to be abroad while the crime was committed, the documents related to his travel history can be helpful to establish the authenticity of his statement. Number 4 is testimonial evidence. It is the human form of evidence, where a witness in the court can explain the facts in his knowledge. One important form of testimonial evidence is dying declaration, which is dealt under Section 32 of Indian Evidence Act. According to it, written or verbal statements of relevant fact by a person who is dead or cannot be found, or who has become incapable of giving evidence, or whose attendance in the court cannot be procured, are themselves relevant facts. Therefore, testimonial evidence in terms of dying declaration is always acceptable in the court, as it is presumed that a person who is about to die would not lie. How forensic science can play a role in proving the credibility of evidences. Physical evidences such as fingerprints, footmarks, tool marks, biological evidences such as blood, hair, body fluids, and drugs or toxins are all tested under different divisions of a forensic science laboratory. Forensic scientists also help the investigators in preparation of demonstrative evidence such as diagrams for the structure of hair, or in crime scene reconstruction or sketches, etc. Documents division of forensic science helps in establishing the authenticity of various documentary evidence presented in the court, such as signatures of the person on will or forgery of document, etc. Interrogation of accused or victim or witness plays a pivotal role in bringing out the truth. Forensic science can also help the investigating agencies in extracting out the truth by establishing the credibility of statement of a person using techniques such as naro-analysis, polygraph, or brain mapping. In naro-analysis or truth serum test, intravenous hypnotic drugs are administered in controlled manner on a suspect to procure vital information. A polygraph, also known as lie detector, is an instrument that measures and records several physiological indices such as blood pressure, pulse, respiration, breathing rhythms, and skin conductivity while a suspect is asked a series of questions. Brain mapping is a comprehensive analysis of brainwave frequency bandwidths. In this test, forensic experts apply unique neuroscience techniques to find out if a suspect's brain recognizes things from a crime scene which an innocent person's brain will have no knowledge of. However, as a popular fact, this is also known that Honorable Supreme Court has restricted the use of these techniques because the Clause 3 of Article 20 of Indian Constitution 1950 provides that no person accused of any offence shall be compelled to be a witness against himself. Although, in many cases, naro-analysis has proved to be a very important tool of investigation, but it is still regarded as a breach of fundamental right of an individual, and owing to these legal obligations is always under question. There are further subcategories of evidence which might fall under any of the above heads. Presumptive evidence. Owing to unavailability of strong evidence, certain facts about the case may be presumed unless proved otherwise. Circumstantial evidence. The fact for which no real evidence can be provided, however, the presented circumstances are indicative of it. Conclusive or incriminating evidence. The authentic and substantial piece of evidence which can alone help to reach the conclusion. For example, CCTV footage of accused committing the crime. Conflicting evidence. The evidence which might not be relevant in itself but raises suspicion on authenticity of some evidence. Corroborating evidence. The evidence which may not be strong enough to reach a conclusion but is supportive of the other evidence presented. Derivative or tainted evidence. If the authenticity of the source of evidence is under suspicion or it is found to be acquired using illegal means, it is not admissible in the court. Foundational evidence. Evidence that determines the admissibility of other evidence. Rebuttal evidence. Evidence which is provided in response to other particular evidence to contradict its authenticity or prove it futile. Exculpatory evidence. The evidence which can disprove the guilt or establish the innocence of the accused. Hearsay evidence. It is the form of testimonial evidence. However, it is not based on the facts directly known to the person, but upon what he or she has heard from others. The authenticity of such evidence is always under suspicion. Talking about the admissibility of evidence, according to Section 136 of Indian Evidence Act, it is up to the discretion of the judge handling the case to consider an evidence relevant or futile. Therefore, it becomes the responsibility of the judge to make sure that every relevant evidence which is obtained legally is made admissible in a case. Here, it is also to be mentioned that verdicts or decisions passed by the Honorable Supreme Court of India and state high courts also act as guideline for the lower courts and can be helpful in deciding upon the admissibility of a particular evidence by tracing similar case histories. The reports generated by Forensic Science Laboratory after analysis of any evidence submitted by the investigating agency is admissible under Section 293 CRPC. However, the reports as well as the testimony is dealt under Section 45 of Indian Evidence Act as expert opinion, which has already been explained in our video on criminal justice system. Drop your queries in the comment section or reach us on our different social media handles.